Welcome to another edition of Law Talk. I'm Clay Williams. I'm a partner at FH&P Lawyers, and we've got a very interesting topic today. I'm here with our special guest, Colin Flanagan. Colin, welcome.
Thanks for having me, Clay.
Colin is here to talk about MAID. And Colin, I have to say you have won the contest about the most brief speaking notes. I've got 3 words. So, and I understand it's because you've been speaking on this topic quite a bit. And you're just off another talk that you just did. Is that right?
Yeah, I just did a presentation for the Canadian Bar Association on the topic. So, for those of you who don't know, MAID is medical assistance in dying. It's obviously an evolving area of the law, and it's something that is very personal as well too. So because it's always evolving, I find that I do get asked a lot for doing either presentations or people having questions about, okay, what is it? What does the law actually say now? And one of the big hot topics is what's changing in the law, because it is still such a juvenile, young area of the law. It's in a constant state of flux. It's constantly changing, and it's currently changing now while we're talking, and it's going to be changing more as well too. So, it's one of those topics that people care about and do want to know what's coming next because of how much it's already changed even in the last 10 years. Prior to 2014, before the Supreme Court of Canada decision in Carter, it was a criminal offense. It was a blanket prohibition from being able to assist someone else in taking their own life. It wasn't until the Carter decision now. Trial decision was a couple years earlier, but it was when the Supreme Court of Canada decision said that it was unconstitutional to have a blanket prohibition. Then that's really when the law changed. Now, there was changes done to the Criminal Code of Canada through Bill C-14, but it did take some time for that to change because the law was so entrenched for a long time in trying to figure out how did the judges look at this as far as potential changes. And that kind of goes to back to the original trial decision and looking as far as what kind of procedural safeguards might be appropriate. Because when we're talking about this significant of a change in the law from blanket prohibition, not allowed at all, criminal offense, to all of a sudden allowing it, it needed to be set up in a structured way. And the way it got structured was as an exemption under the criminal code. So even the changes to MAID that allow it are actually right in the criminal code itself. And, it's about trying to find a balance as what's the right fit for Canadian society. Because each society that does have varying degrees of allowing this, it's different because those societies are different and how they look at what they wanted to permit for this. So as an example, when it first became law in Canada, it was a bit more on the restrictive side, to be quite frank with you. And there was other challenges that resulted. There's a couple of cases, the Truchon case, there was the Audrey issue as well too, where she ended up, poor lady Audrey Parker ended up taking her life earlier than she intended to because of some of the safeguards that were in place from the outset. And so it is an area of the law that's already gone through a couple of major changes now. So, as a kind of brief primer on it, basically, if someone is suffering from a grievous and irremediable condition.
And you're talking about the procedure right now.
Yes.
And I understand it's in flux, but this is the procedure right now.
Yeah, so the procedure...
Who qualifies, I guess, and what the procedure is.
Yeah, exactly. So right now to qualify, you need to be diagnosed with a some people take it as terminal, but the concept is going to be a grievous and irremediable condition. And that is one that's going to be causing death. Now, there is 2 categories right now for whether or not death is reasonably foreseeable or not reasonably foreseeable. And it's slightly different processes or pathways in which people go down. So for right now, say if someone is suffering from a condition and they want to qualify, usually they first start talking with their family doctor, maybe even a social worker as well too, if they don't have a family doctor, because it does require 2 medical opinions that you are diagnosed with this condition that qualifies. And, when death is reasonably foreseeable, there's a kind of a set process as far as how you go about it. But when it's not reasonably foreseeable, there's a little bit more to it. And especially not only the time period, but also...
Can I ask you, just in hearing you talk, so there must be an illness or a condition that is going to cause death? What about a condition that you're in pain all the time, 24/7, I want this to end? Would that qualify right now?
Probably not.
Oh, that's something
and
else.
So the reason why I'm saying probably not, though, is because the types of illnesses that qualify is one of those things that is changing. And the change that's going on right now, and it's been the change has been set to happen for a couple of years now, but it keeps getting pushed off, is it has always previously been need to be a physical illness that's going to be causing death and that's grievous and irremediable. But it's the purely psychological illness. So this came from a joint parliamentary committee report that was done a number of years ago that had there's a number of suggestions, but two main ones really came out of this. And one of those was to open up MAID for people that have purely psychological illnesses. Now, this has been planned, people have been working on this for a number of years now. There's still a lot of disagreement even within the world of psychology, as far as, there's some illnesses about, is it terminal and is it permanent as well too? Even if you look at concepts, say like suicidality, right? This is a very difficult concept because there's a lot of, sounds like some subjective opinions when it comes to when someone is going to potentially qualify. So as far as even within the world of psychologists, having people come to agree to what those standards are going to be for qualifying. So, there is already one change coming up as far as what type of illness might be involved in it. One of the other illnesses that often gets brought up is ones with diminishing capacity. And that is something that's a little bit more complex, in all honesty. And that is the idea on advanced consent. Now, this was something that I was just touching on a little bit earlier about with when death isn't reasonably foreseeable. Right now, you need to be able to have capacity to give a final consent before the procedure occurs. Now, going back to that joint parliamentary committee report, the other major, as I said, there was a number of things came out of it, but one of the other major ones that came out of that was the idea about doing an advanced consent or waiving advanced consent. Now, right now that might only be possible when death is reasonably foreseeable, but not in the other pathway. And so Quebec right now has actually taken some further steps with Bill 11, in which they've already taken some of those concepts from that joint parliamentary committee report and looked to pass it into provincial law about allowing for people, even when death isn't reasonably foreseeable, to try to provide that advanced consent. So if they were to lose capacity later, like if you have a diminishing illness, this is a real concern for a lot of people.
So like an enduring power of attorney, if something happens to me down the road, or do you already have to be suffering from that?
You'd already need to be diagnosed with the illness, was the way that the Quebec legislation is geared towards, because that's kind of where they went with the Joint Parliamentary Committee report. And that was, if you get diagnosed with it, being able to provide that advanced consent. Substitute consent is something entirely different, okay? So when it comes to the advanced consent, though, Quebec has already tabled this provincial legislation, and they've sought to get exemptions from the federal government or maybe even from the RCMP about not prosecuting because it's not been changed in the criminal code yet. And right now, it doesn't look like that's going to be granted. And so that has created a bit of a gray area, on this push in Quebec to try to allow for this advanced consent.
Okay, so let's recap. There's a lot. There's a lot to unpack here, okay? So right now, to qualify for MAID, you have to be diagnosed with an illness that is going to cause you to die.
The wording is, under the criminal code, is the grievous and irremediable condition. So when you're thinking about this terminal concept, that's usually captured under that grievous component.
Yeah.
And so that's having the grievous and irremediable condition. And currently speaking right now, that's only physical illnesses. It does not include purely psychological illness.
But you're going to die from it. Is that right now? Or does grievous and what is the word?
Irremediable.
Irremediable. So, that's an arguable wording. But I think I'm just trying to pin you down. Do you have to be diagnosed with something that you're going to die from right now?
So, to qualify as a grievous and irremediable condition, right now, I'm not aware of there being any conditions that are qualifying as grievous and irremediable that are not terminal. Okay? Now, when it comes to being the terminal element on that, the question is whether or not death is reasonably foreseeable. As in, it's terminal, eventually you're going to deteriorate to the point where death is going to be inevitable, or is it going to be you're in the process of dying now? And I think that's what you're trying to pin me down on here. And what I'm saying is that's where those two pathways come up, right? When death is reasonably foreseeable, as in it's causing your death right now, and we know you're going to be dying within the, say, next couple months, maybe like 3 to 6 month type of diagnosis. Well, that's when you might be looking at that first pathway, right? That death is reasonably foreseeable, and then you go through more of a simplified process in qualifying for MAID. When it is in the death is not reasonably foreseeable category, that's a slightly more of a process. It does require, in the second opinion, about making sure it's someone who specializes in that area, or if they don't, for the second doctor's opinion, they have consulted with a specialist in that area.
And is this path for a condition that is, say, for instance, causing a whole lot of pain and ongoing suffering? Is that why somebody would qualify for that path rather than death is imminent?
Well, I wouldn't use that terminology. And the reason why is because one of the big changes we've seen and made over the last couple of years, and are going to see more of this, is looking at less of a focus on the lawyers and the law on this component and having more of a medical input, right? As far as based on whether you're looking at it from a health authority's perspective or even kind of the doctors within a certain field or area, looking as far as what are the standards as far as determining what qualifies as a grievous and irremediable. They've got the wording from the criminal code. It's going to be on medical standards. What is going to be accepted as being a qualifying criteria for that?
Do you have some examples of illnesses that have qualified? I'm putting you on the spot here, but
As far as ones that I've seen people go through on,
yeah.
Example, there's different forms of cancer people have been going through that have then qualified and obtained MAID. People that have, say,
ALS, I've heard.
Parkinson's, ALS, yeah. There's a number of different diseases that will qualify. So when people have that question of saying, okay, well, I've got this illness, will this qualify as grievous and irremediable? It's going to come down to the medical opinion about, in the doctor's opinion, a lot of times it requires two opinions, saying, is this a grievous and irremediable condition that qualifies for MAID? And I hate to use the term.
But doctors are human beings too, so that's an opinion. Hopefully, those opinions will need to be guided by, some kind of criteria.
And they often are when it comes to as far as health authorities looking as far as what qualifies. But you do have differences of opinions in doctors, right? And there has been this concept, and it's been around since about 2020, about people doing, quote, doctor shopping. Right? And saying one doctor might find that your diagnosis isn't grievous and irremediable, but another one might. And that's an alarming concept. One doctor might not agree with the concept,
one doctor might,
and it's an alarming concept. Yeah. But you know what? That is kind of the reality, is that there is that situation. And, we've even seen issues arise where this does come into the courts, where someone maybe feel if they don't have capacity and it's a loved one, we're saying, I don't think this person should qualify because their family doctor doesn't think they qualify, but yet they've gone out to this other doctor who now says they do qualify. And we've seen injunctions being obtained by family members now trying to prevent it, whether they're worried about them being unduly influenced, lack of capacity, or maybe not even having a condition that maybe does qualify.
Okay, now we've only got so much time here. I know that you're the authority on it.
Let's not go that far. I wouldn't say authority.
You did warn me before we started. You said one of your talks went on for 2.5 hours. So we don't have that much time. Now, what about capacity? And I guess this is something that I'm curious about. Like if a person gets diagnosed with a qualifying illness or condition, and you're deteriorating.
Yep.
Now, that's scary, man. I mean, do I have to catch it before I lose capacity, or can I say, okay, I've got this, I qualify, and I'm going to give, I guess, the decision to somebody else to make this what I've...
Substitute decision making is something completely different. Okay. So when it comes to some of the changes we've already seen, that was, Audrey Parker and Chouchon, those were exactly going down this road. And that's where we have the ability to maybe give advance consent when we're looking at when the death is reasonably foreseeable in that first pathway. The problem that a lot of people are looking at is when it's in the second pathway, when death isn't necessarily reasonably foreseeable. Like, you're going to still pass from this illness, but it might be a year or two, but it's going to be degenerative in nature. And the worry is at some point, are you going to lose capacity and lose your ability to consent to have the procedure gone through?
Yeah.
And that's where, going to go back to where Quebec was going with Bill 11. And that was from that same Joint Parliamentary Committee report that put forward the idea on having purely psychological illness. This is one of the other topics that got addressed and saying this might be a change we should look at as a country and as a society. And, that might be a change that gets looked at next. I think there's been a lot of focus right now on the purely psychological illness. After that, there might be renewed focus on this idea on doing the advanced consent, even when death isn't reasonably foreseeable.
Okay, so let's just put a pin in the psychological stuff for a second.
Yeah.
So right now, though, if I've got a degenerating illness that is going to kill me, I better catch myself if I want to get MAID before I lose capacity, because as soon as I lose capacity, I can't. A person's not going to be able to have MAID. Is that right?
If you're in the second pathway where death isn't reasonably foreseeable, that's a problem, because you need to have the ability to give the final consent before the procedure. If you're in the death is reasonably foreseeable pathway, you can give an advanced consent in some circumstance.
Is it a date that I'm giving, or is it, I'm just wondering how it works.
In the advanced consent one, when you are saying the death is reasonably foreseeable, as part of your application, your approval, you can ask to be able to have the authority to waive that final consent or provide the advanced consent for it and saying, I'm not going to change my mind. I know I've got the right to change my mind. I'm not going to. I'm worried that I might lose capacity. And if you're in that first pathway, you might be able to qualify for that. But if you're in the second pathway, where death isn't reasonably foreseeable, you're hitting the nail on the head. What a lot of problems people are finding here is saying that there's this gap. And that is, if you lose capacity, you lose your ability to have the procedure undertaken. So some people, the worry is, might be choosing to undergo the procedure before they would want to, because they're worried about losing the ability to provide that final consent. And substitute consent is something that is not the law. We are not allowed to give substitute consent, whether that be from a representation agreement. Right now, that's not the law. And I know some people think that might become the law. Some people think it might not ever become the law. And when you look back to the original Carter decision at the trial level decision, this is one of the topics that was looked at, was about whether or not it should be expanded to allow for substitute consent. And looking at, it was a British Columbia trial decision with looking at representation agreements. And that was one of the decisions that was made at that time, that they chose that was not something that made sense for doing this change in the law.
Although it seems to me it may lead to people asking for MAID earlier than they might otherwise do, because they're worried about just that situation.
True, but there's a number of other problems that arise when you look at substitute consent, because who are the people you would name in your representation agreement? And for those that don't know, representation agreement is for if you lose the ability to make healthcare decisions, including perhaps end-of-life decisions under Section 9 representation agreements. It's someone that can make that choice. The types of people we're naming in those documents are people we trust, right? Close family members usually. And those people are often the beneficiaries of our estate, whether they're beneficiaries under a will, beneficiaries under life insurance policies, TFSAs, RSPs, RIFs, those sorts of things. And at law, we've got the problem what's known as ex turpi causa. And one of the things we're even seeing with MAID as well too, if someone doesn't have the physical ability to sign the request, someone else can sign on their behalf as a, quote, proxy, as that's worded under the criminal code. But the people that cannot sign even as a proxy, people are going to benefit under someone's estate. So that's a major issue when you look at substitute consent. Who would be the ones you would want to be able to make that decision? But then we have a problem about whether or not they should be allowed, because they're going to be the ones benefiting or maybe even profiting from your death. You don't want someone doing something for untoward reasons. Now, that's probably a gross minority, but it's still an issue that needs to be grappled with. So, if we ever do look at substitute consent, it's going to be a very complex issue, and it's not going to be a quick change in the law. If that ever becomes a change in the law, it's going to be a very complex and nuanced process.
All right, so let's go back to the changes that are happening right now with the psychological issues. So what's going on? You touched on it, but in my mind, I was thinking back to some of the
you were ignoring me a little bit.
Issues. So what's happening now?
So it's been passed in law saying that it's going to need to be changed to allow for purely psychological illness, but the date in which that needs to happen by has been pushed back, and it's been pushed back. And so I was hoping that last year was when it was going to come in, for earlier this spring, but it got pushed back again. So it seems like there is still a lot of debate.
So is this psychological, like people that are suicidal or unhappy and just cannot, through a bunch of treatment, turn the corner, I guess.
Well, there's a number of different complex issues. Like, it's not just one or two. I'm just picking up and pointing out a couple of the ones, but there's numerous other issues that are being grappled within the different realms of psychology, psychiatry, other areas as well too. You know, one of the examples, I'm just pointing out how complex it can be. I'll go back to suicidality again, right? As far as suicidality, you look at that, someone wanting to take their own life is a psychological illness. You know, that can be grievous, right? But one of the big issues is irremediable. Is it permanent, right? And what is perhaps maybe another underlying condition that's related to that as well too? Or is it just purely that? When you've got other underlying conditions with that, is it truly irremediable when it can be perhaps something that can be treated? If it's, say, tied with bipolarism as well too, what is the effect of different types of medication? Is it truly irremediable or not? That's what I'm saying, is that this is a very complex area with a lot of subjective elements in purely psychological illness, that there's a lot of still disagreement amongst the medical professionals on what should be qualifying and maybe what shouldn't qualify.
So when you say it's been pushed back, was there actually a court decision that says that the law must be changed in that regard, or is this just a discussion that's happening?
No, it actually has been set by law in bills that have been passed in the House of Commons. And that is about saying that the directing to change the criminal code to allow for purely psychological illness, but that date in which it said it needs to happen by has been pushed back a couple of times already.
So you think it will happen at some point?
Well, all of the indications are, and I mean, it's already been said that the law needs to be changed to allow for this, and that.
Well, that's what I was. So it does have to happen. It's just.
It seems at this point it's just a matter of time until there is a consensus.
It's a political.
It can be very political as well too. The amount of
bomb, I would think, whoever's going to implement it is going to have people that are happy about it and people that aren't. So you can see why it'd be pushed back.
Well, to be quite frank with you, since that Carter decision in 2015, I've lost count of how many member bills have been brought forth about recommending different changes to MAID as well too. It can be a very political, because it can be such a personal topic, right? And when it's such an important topic, talking about someone's life, right? When someone isn't happy with the way the law works on it, they're going to be very vocal. And, politicians are responsible to their constituents. And so when people are saying, I want this law changed because this is the problem I faced, you're going to have a lot of politicians will listen to their constituents and want a change in the law as a result of that. And what changes are actually going to happen? They can happen from court cases, judges deciding that something isn't constitutional. It can be brought forth by the legislature as well too, by saying, this is what we think the law should be changed to. So, there's many different ways that can cause the law to change in this area. And it has changed a lot, because the law, generally speaking, while it's constantly changing, massive seismic changes don't happen overnight. And in the case of medical assistance in dying, this has been a pretty seismic change in the last 10 years.
Yeah, no, you're right. From criminal to an actual procedure. So, all right. So now we've only got so much time. Did you have any other things you wanted to say, or I'm going to wrap it up?
If there's any other questions you got for me, I'm happy to answer them. It is a very complex topic, so I'd be quite frank with you. So what I'd encourage people to do is, if they've got any questions, take a look online yourself, but of course, talk to your professionals as well too. If you've got questions about an illness you might have, talk to your medical professional. If you've got questions about how this maybe impacts things like your will or any of your life insurance documents, especially if you've got something that's outside of Canada as a jurisdiction, talk to your professional advisors, talk to your lawyer, maybe one, say, in Canada, but also if you maybe have a life insurance policy in Florida, talk to your Florida advisor as well, too, about if you went through this process in Canada, make sure you're not going to lose that policy or qualifications for it.
Okay. All right. Well, we're really lucky to have had Colin. And so, Colin, I do know that you do quite regularly do talks on it. So watch our website. And we do speaker series, and Colin appears on that on occasion. So thank you very much, Colin. And with that, until next time, thank you.